And welcome to this webinar on COVID-19 affected topics in our Shared and Halved series. The point being, as we all know, a problem shared is a problem halved. My name is Sebastian Price. I'm a partner in the commercial group at Shoesmiths, and I'll be moderating today's webinar. And I know some of you who've been on these before will have heard this before, but bear with me just for those whom this is the first one you've attended. Let me just explain that our Shared and Halved programme is designed to bring together different interest groups to share thoughts, see if we can answer questions. So this is one in the series for in-house lawyers, and we've intended them as, we call them bite-sized morsels, suitable for a coffee break, half-hour coffee break, and we want to give you practical tips. And we're really keen on keeping up a conversation with you rather than just bombard you with a load of stuff. And as I keep on saying, this situation is going to end one way or another. I'm sure things are going to be different. Let's see what the government says towards the end of this week about relaxing lockdown. But the point is, for us, let's be sure that we're ready for when things do change. And to help with this, please keep an eye on our main COVID-19 hub on our website, because there's a special page there for you, for in-house lawyers, where we're putting up useful resources, a recording of this webinar, for example, key takeaway notes, and also information on future webinars. So please keep an eye on that. And of course, we want these sessions to be in line with what you want, what's useful for you. So please do send in questions or anything at all, and we can shape a webinar around what you want, which is what we've done here. So this session, we've had questions about court proceedings. So this session, we're going to cover what you can and can't do in civil proceedings in the current situation. And I mentioned questions, so if you've got questions during the session, please just send them in using the Q&A function and we'll try and answer them. Okay, so this morning on the panel we've got Kate Draper. She's a senior associate in our commercial litigation team. She's actually currently dealing with various commercial disputes and including some complex debt recovery. So she knows all about court processes, procedures. So I think she'll give us a fantastic insight into what we need to know on that front. And also Stuart Montgomery, who's a partner who runs teams dealing with general commercial litigation and also banking and finance litigation. So much of his work involves recovery of debt and recovery of property. And so he specializes, for example, in the enforcement of mortgages, personal guarantees. Right, let's get going. Kate, if I could start with you, just give us an overview of what measures regarding court proceedings have been put in place regarding lockdown.
Sure. So there's been, first of all, there's been loads of rule changes and legislation changes, so I'll just summarise some of the key ones for you. First of all, there's new legislation in the form of the Coronavirus Act 2020, which received royal assent and became law on the 25th of March. This is the act that provides the legal basis for the current lockdown of citizens and businesses, and it puts in place a whole host of emergency measures designed to handle the coronavirus pandemic. In the context of the courts, it amends existing legislation to enable the use of technology in hearings so that parties can appear before the court using live video or audio links. There are also proposed changes to insolvency legislation, which are due to come in force in the next few weeks. It's anticipated that these will include provisions such as relaxation on wrongful trading rules and temporary bans on the use of statutory demands and winding up petitions. There have also been a number of changes to the civil procedure rules, including the addition of new practice directions relating to extensions of time and video hearings during the pandemic. And then finally, the courts themselves have also implemented different rules, which at the moment is resulting in many, many hearings being adjourned.
Okay, but what would be the practical effect for somebody who, for example, wants to start a claim?
Morning, everybody. First thing to say is that under normal circumstances, if you were looking to start a claim, you would give the other party plenty of notice. You would write to them and you would set out what you were planning to do. Most litigation is covered by what we would call a protocol, and the intention of the protocols is to allow the parties to both exchange information, set out their stall, as it were, and allow the other party to be fully aware of the claim against them. The protocols are set out by the civil procedure rules, which Kate just mentioned, and the intention is that parties should, if they're able, settle matters without the need to bother the courts and without involving the courts' scarce resources. The thrust of much of the current civil procedure rules is based around trying to promote settlement. So in those circumstances, if you're looking to start a claim, or if a claim is potentially going to be started against you, there should be plenty of time in correspondence in order to deal with matters. One of the questions we've been asked is, what happens if I'm not able to get into the office? What happens if there's posts sitting there or potentially a claim sitting there? Should I, can I get away with that, or what do I need to do? The answer is that there have been no provisions whatsoever allowing you more time to respond to correspondence, and there's nothing in any of the provisions that Kate set out which would avoid the need to respond to a claim which has been issued. So we would urge you to ensure that somehow somebody is checking the post, if at all possible. I suppose on a practical basis, if you know you're in dispute with somebody, communicate with them. Make sure that they're aware that they need to communicate with you by email. And then perhaps you have got some grounds, if a claim is issued, for jumping up and down before the court and saying, this is outrageous, I warned them I wasn't in the office. But I wouldn't rely on that. I think our advice would be try and make sure that post is being redirected and picked up somehow. I appreciate that's not easy, however. What has not been affected is urgent matters. So this is obviously a civil litigation session, but for example, restraint orders against individuals are still getting hearings remotely by video link. For you in the commercial setting, what that means is if you've got injunctive relief that you're seeking, you should be able to get before a court fairly quickly. Most injunctions are dealt with without warning to the other side anyway. So in those sorts of cases, we would expect that you'd be able to get a freezing order, for example, before a court fairly quickly by way of a video link. And certainly we've got counsel working on those, and they seem to be going ahead without any problems.
Thanks, Stuart. But Stuart, any practical tips you could give?
So if a claim's issued against you, you really need to make sure that you comply with the court deadlines. So if it's a straightforward monetary claim, somebody seeking a debt from you, you've got 14 days to respond saying that you intend to defend it, or you intend to pay it if that's the case, and then another 14 days before you need to file your defence. So if you do find that there's a claim, you've got to act quickly. Now, in practice, you may be able to agree an extension with the other side. In other words, the other side might give you more time to file a defence, but I would be very careful to try and either hit court deadlines or at the very least speak with the other party and try and extend them.
Yeah, okay.
The other thing I'd say is that whether this is a potential claim or whether it's a claim that's actually been issued, the courts do promote settlement, and we'll go on to settlement perhaps later in the session as to what settlement options are available.
Okay. Well, when you talk about Kate, perhaps I can ask you. When Stuart just talked about already issued claims, what happens with those, with ongoing claims?
So in terms of ongoing claims, to start with, I should start with possession and residential property. Possession of residential property and bankruptcy hearings are all being adjourned at the moment. So those aren't currently being progressed at all. But most other claims are proceeding. And so, as Stuart mentioned before, it's important to make sure that your court deadlines are being complied with. The consequences for failure to comply with deadlines can be really, really serious. So, for example, failure to file a defence can result in default judgment being entered against you. Failure to serve witness statements can result in a party being debarred from filing any witness evidence altogether, or from calling witnesses to give evidence at court. So there are real risks if you don't comply with your court deadlines. And the coronavirus pandemic hasn't altered these sanctions in any way. The deadlines are still strict. There's no kind of moratorium on these time limits. There has been, as I mentioned earlier, a change to the practice direction. So there has been a new practice direction 51ZA, which allows parties to agree extensions of time to comply with procedural time limits and court orders of up to 56 days, as opposed to the usual 28 days, provided that that extension doesn't put any hearing date at risk. So in cases where you do need more time, I'd say in the first instance, look to agree an extension with the other side. But I would caveat that by saying that, do read the wording of your order and make sure that in your particular case, the court hasn't expressly stated that its permission is required for any extensions, because in those circumstances, you're then going to need to make an application to court. Similarly, in cases where extensions can't be agreed, an application should be made for more time. And you want to make sure that you're making those applications before the deadline passes to avoid being in breach of sanctions. If you've already missed a deadline and you're looking to file late, then the application you're going to be making in that instance is an application for relief from sanctions, which is a much harder hurdle to overcome than a simple request for an extension of time. But the new practice direction, the one that I just mentioned, does direct that the court's required to take into account the impact of the pandemic when considering applications for extensions of time as well as relief from sanctions. So if you are impacted, if the reason that you're struggling to meet a deadline is as a result of COVID-19 in some way, shape or form, then the court has been directed to take this into account. And then in terms of hearings themselves, the courts are increasing the use of telephone and video hearings remotely where possible. There's been the addition of another new practice direction 51Y, which relates specifically to video and audio hearings during the pandemic. So the court does say that it has that facility and that it will have remote hearings where possible. Although in practice, what we are finding and what I've certainly found is that I haven't had any final hearings or trials going ahead. They seem to be being adjourned at the very last minute. But it may be possible that, some will go ahead in future once the courts get up to speed with the technology.
Okay, thanks, Kate. So, Stuart, back to you. Bearing in mind what Kate's just been saying, what practical advice would you have?
So the first thing I'd say is that if you have got a hearing coming up or a deadline to meet, you should start off by assuming that you have to prepare for that hearing or meet that deadline. Certainly an ongoing litigation where you have the normal obligations to deal with disclosure of documents, exchange of witness statements, etc. There's no reason why those things cannot take place in accordance with the schedule that the court has not only set, but ordered you to meet. And I think this answers another one of the questions that was raised, which was how do I deal with gathering documents for disclosure or otherwise when I'm not actually in the office? Certainly the court would expect that you would deal with disclosure as fully as possible. and there is a requirement to sign a statement of truth saying you've carried out a full and proportionate search for documents. If you're unable to do so, again, as Kate mentioned, you will need to make an application to court as early as you can, asking to extend that time or perhaps to deal with disclosure in a different way. So practically, keep an eye on the deadlines and make applications early. With regards to directions, Kate mentioned that there is the scope to agree extensions between yourselves up to 56 days now. If possible, do that. Certainly when you've got lawyers on both sides, we do find that we are usually able to resolve those sorts of issues. If directions can be agreed, it might be possible to save the court's time and not actually need a hearing. The court might be able to agree everything on paper. And the last point which Kate made was, yes, we have been arranging remote attendance, whether it's by telephone attendance or otherwise, but in our experience, the courts are mostly adjourning things. And certainly the last few hearings I've had, whether we've had lawyers involved or not, have been, unfortunately, adjourned.
Okay, but Stuart, apart from the classic court proceedings you've been talking about, what about other routes for recovering debts? I mean, for example, winding up petition, suing individuals with a guarantee, whatever.
So in terms of pursuing guarantees and just normal county court or high court debt claims, yes, you can proceed with those, and yes, you can serve in accordance with your agreement or your guarantee at whatever address is stated. And as Kate mentioned, it might be possible for you to get default judgment if they don't apply. In practice, I think you may find applications for extensions of time, in other words, to allow the guarantor or the debtor to have more time. But there's no reason you can't proceed. The law hasn't changed in that regard. With regards to insolvency, there is a corporate governance and insolvency bill which is before Parliament, and we are told that it will be brought forward. Kate mentioned that was the bill that's going to be brought forward in the next couple of weeks. We don't have full detail about it yet. The only thing that the government has said, and this actually answers a question that's just been raised by the panel, the government has said that if you are a landlord seeking payment from a tenant, you cannot either serve a statutory demand or petition for winding up or forfeit the lease under the current circumstances. Now, we don't have any more detail on that at the moment, but just to sort of give a bit more detail on that, the normal procedure if you're recovering a debt and you are looking at winding up the company for being insolvent is you would need to demand the debt and set out how much it is. That can be done by what's called a statutory demand, which gives an individual or a company 21 days to pay. And if that demand isn't paid, you then present a petition to the court, and either the individual can be made bankrupt or the company wound up. Now, in terms of landlord and tenant, government has said you can't do that at present. With regards to other bankruptcy and winding up proceedings, there are a number of practice directions. These are directions set by the courts themselves dealing with this. And in summary, most bankruptcy and winding up hearings where a company would be wound up have been adjourned, and looks like they're likely to be adjourned for a period of, well, it was 12 weeks. We're probably about 4 weeks into that. The picture isn't entirely clear because each different court seems to have a slightly different rule. So, for example, the business and property list in London is slightly different to the Central London County Court. But again, in my experience, having issued a number of bankruptcy petitions and winding up petitions and having them due to be heard over the last 2 months, not one of them has been heard. They've all been adjourned post-June at present. One final thing to say, though, is that for companies that are in financial difficulties, there's nothing to stop the company winding itself up by the voluntary route, placing itself into administration, or possibly, if it chooses to, looking at a company voluntary arrangement. And certainly, I have remotely witnessed a statutory declaration for another firm of lawyers where they have put company into administration in the last few weeks. So those remedies are still possible.
Okay, thanks. Stuart, just to carry on from that then, what should we do if we're chasing a debtor?
So I would follow the usual route of making sure that you make contact early if you're seeking payment of a debt. Again, under the protocol, if you're thinking of issuing court proceedings, there are certain things you would need to set out in terms of making sure that you're clear as to what the debt is and what interest rate's been applied, etc. And make a formal demand for payment. Quite often your contract will require that as well. And whatever contract you're suing under, whether it's a guarantee or whether it's just a debt by a company, make sure you serve at the right address. In terms of the practical problems you may have, certainly if you're issuing a simple claim for debt, there's no reason why you can't do that. Using the Money Claims Online service, you don't actually need to go anywhere near a court, and you can use the online service. However, if you're looking perhaps to serve a statutory demand, there are practical problems because you're supposed to effect what's called personal service, which means in normal circumstances you would hand the demand to the debtor or your agent would. But I don't see any reason why we can't get around that. Delivery drivers are able to leave things on doorsteps, and I think you should be able to serve the stat demand, but I think you're going to struggle to actually get that petition heard. But what we'd say is prepare everything in advance, make sure you've given notice to the other side of what you're intending to do, and then once the court service is back up and running again, you should be in a pole position to go ahead. We expect that the courts will be very busy once this is over. So if you can get everything lined up, ready to go, I think you would be in a better position.
Okay, that's great, thanks. Stuart, so just picking up something else you mentioned earlier about the focus on settlement. Could you tell us a little bit about settlement remedies, how that would work?
Yes, so the courts are very keen for parties to settle without using the court's resources. Courts are very busy and it's taking a long time to get hearings anyway without the current pandemic. And we certainly encourage commercial clients that it is usually commercially better to seek settlement rather than incur the cost of litigation. There's a number of ways of doing this. You can just write with an offer agreeing to cap the liability one way or the other. You can perhaps agree installment payments or some other remedy. And that can be done in correspondence or just by telephone calls. Another alternative is what we would call alternative dispute resolution, or ADR, which is really just people in normal times sitting around a table trying to thrash out a deal. The more formal route is a formal mediation, where you have an independent, trained mediator who undertakes what is in effect shuttle diplomacy between the parties. We all meet, we all sit around a table and discuss our respective positions, and then under a normal mediation, we all go off to separate rooms, and the mediator will go around each room trying to thrash out a deal between us. And we can still do those remotely. I managed to settle one 2 weeks ago. It was a £300,000 claim with 3 parties involved, and it settled. We did it via Zoom, and there is the ability for the technology to put you in different rooms and to connect you all, and it worked perfectly. So don't think that everything's on hold. If you do want to try and thrash out settlement of a new problem or an existing problem, that is still very much an option.
Mm. Yeah, I very much agree with that. I mean, in the work I do, I'm seeing companies wanting to think about their supply chain, and rather than immediately leaping on a breach of contract, it's more important, some people are feeling it's more important to keep relationships in the supply chain, and therefore being more tolerant. I mean, that doesn't mean letting people off the hook, but talking about it, and I can see that mediation could be extremely useful, because when you are trying to do a deal with a supplier or a customer in the supply chain, trying to keep it in place, what you don't want to be doing is just waiving all your contractual rights. So I guess you've got to, as lawyers, got to keep an eye on that factor.
Yeah, and mediations really do work.
Yeah. Okay. So, Kate, back to you. I don't know whether it'd be possible for you to just summarise some key points.
Yeah, sure. So in terms of key points that I take away from this, I think firstly, and I know it's something that both Stuart and I have said on a number of occasions already, but it is important. Make sure that you do know when your deadlines are, and as far as possible, ensure that you're complying with them. You know, don't just assume that there is some kind of moratorium on time limits, because there isn't. Where you know that you need more time, seek to agree an extension with the other side in good time. Worst case scenario, if you can't reach an agreement, make an application to court, and again do so in good time before expiry of the deadline. Where possible, I'd also suggest, if you can, agreeing service by email, because this will hopefully ensure that you don't miss any important documents being served upon you, for example, whilst you're not in the office. And it also reduces, you know, issues surrounding you making sure that the other side are getting documents properly and that they're being served properly in the correct manner and on time. So it will reduce that stress as well. And then finally, I think given the inevitable backlog that there's going to be with claims proceeding via the courts, I would always consider looking at alternative dispute resolution methods such as mediation, which in many cases is going to be a lot quicker and probably the more cost-effective route to take.
Okay, great, thanks. I think a final thought, Stuart, perhaps you could comment on this, just going back to what I said about preserving supply chains. Just as a matter of market practice, I don't know, just seems to me that the attendees to this webinar might be interested to know if you've got any view of, is there any market practice that you're seeing in the way people are deciding how fiercely to press claims in a supply chain situation?
Yes, certainly. We've got ongoing litigation for one of our commercial clients, which is my client is being sued. It provided an expensive bit of machinery, sort of £500,000 worth of kit that allegedly had some problems with it. And although we're in dispute, my client is very keen not to go to court, even though we're comfortable that we're going to succeed, because to do so would incur costs which could wipe out its customer, which doesn't do either of the parties any good. And certainly the one I settled 2 weeks ago was very similar, in that there was no appetite at all to go to court and incur hundreds of thousands of pounds of legal costs, which would prejudice potentially the existence of the business. These businesses tend to operate in the same market, and you know they want to come out of this with customers who can still buy goods from them.
Yeah. Good. Well, thank you both very much. I think you know we'll draw to an end, so we're at 11 o'clock. Thank you to everybody attended. Thank you very much for joining us on this webinar. Hope to see you next Wednesday. We've got one on insurance issues, insurance recovery of COVID-19 related losses, which I think will be really useful and interesting. And we've got others. As I say, keep an eye on our website. We've got others planned there, and let us know other ones that you think could be useful for you. So for now, thank you again to everybody. Thank you, Kate. Thank you, Stuart. And goodbye for now.
Thank you.
Thank you.